Thank you so much, and we apologize for the short delay. It's been a very interesting but rather long day, and I think we're getting a little bit punchy, but we're very enthusiastic to hear your testimony, so thank you.
We're always last, and you're always punchy, so that's good.
I'm not sure if we're punchier or... So welcome.
Okay, so I guess we can officially start.
Absolutely.
I guess I'll introduce myself. My name is Larry Wood. I work as a community organizer at Goddard Riverside Community Center. I've been on staff there 27 years, and hence have been coming down to the Rent Guidelines Board for 27 years. So I've seen many chairs and many members over the years, and I have made a tradition of thanking everybody for their service, because it is largely a thankless job. You get vilified by tenants and landlords alike, and it's a tough balancing act that you all have to go through each year. And, you know, it's a very frustrating exercise for tenants and landlords alike. I think a lot of people are frustrated with the one-size-fits-all rent increase because you have so much to balance. You know, ideally, we should look at open the books of every building and see what really warrants a rent increase. And if you did means testing, you could figure out who actually could afford a rent increase. But that's not the system, not anywhere close. So we do have to grapple with imperfect studies, flawed data, and a lot of anecdotal testimony that comes before you. But through all of that, you do have to come up with a decision. And I know people have also complained over time that the fix is in, that it's already been decided, and that this is a useless exercise for us to go testify. But I know that's not true. I do know, in talking to members over time, that there's a real battle for the hearts and minds. The tenant reps and the landlord reps are really looking for the public members to side with them. And I do know historically the chair has tried to strive to get the 5 public members to vote as a group, because that fits the narrative of they split the baby. The landlords are upset, the tenants are upset, we did the best we can. So I know historically you do deliberate, you do listen, so that's why we're here, and I thank you for the opportunity. You have before you a couple of submissions. There's 4 items that I want to quickly walk you through, and then both Clint and Brian will bring you up to speed on some specific cases and buildings and really current stuff, but I'm going to be trying to paint a big picture of SROs. So there's 4 things. One is the chart of the Rent Guideline Board adjustments historically for SROs. There's a Community Board 7 study that I'm going to talk about. Over the past number of years, since 2007, there have been 4 memos that the Rent Guidelines Board has produced. They got data from both DHCR and the Department of Finance, and this had to do with something called the provisos. There's conditions that exist that landlords cannot get a rent adjustment without meeting certain provisos. So we're going to talk a little about that in the memo, what the memos demonstrate about those. And then I created a chart out of some of the data I pulled out of those memos. So going back to the big picture, you know, what is an SRO? I hope you've had some opportunity to learn. But basically, it's units that don't have bathrooms and kitchens or have shared facilities. Sometimes you might have a complete studio and sometimes not. And they come in many different forms. If you see the Rent Guideline Board chart, you'll notice across the top of the chart, they have 5 different categories of SROs. Residential Class A, lodging houses, rooming houses, Class B, hotels, and SRO buildings. Some of these buildings were built as hotels or rooming houses. Many were converted. 1 or 2 family house in Harlem and Chelsea and other areas of the city were broken up into rooming houses, a lot of times during the 30s and 1940s. Some big apartment buildings were also broken up, subdivided into SROs, Section 248 SROs. They have different names and different standards depending on when it occurred in history and what the code, what the building code allowed any particular year. Some of them were huge. There was one, the Ben Franklin, it's called Arnie Avenue now. It's at 77th and Broadway. There used to be 3 apartments per floor, and then it was divided into 56 SRO units per floor, so they were grand old apartments. It's now largely a tourist hotel, but there's still about 40 rent-regulated tenants in that particular building. So there's many types of SROs, but there's still, when you look at the total number of rent-regulated units, is 1.1 million is the approximate number. We're down to, it's only a handful of SRO units, comparatively speaking. Just historically, to give you that big picture, in 1971, it was estimated to be about 165,000 units of SRO housing in the city. And the city actually encouraged the demolition and conversion of SROs. New SROs were not allowed to be constructed going back into the 50s. It was seen as substandard housing, so J51 benefits and other benefits were available to owners who were upgrading that property. So they were being demolished and converted. In the late 70s, early 80s, advocates started to realize we need this low-income housing resource. Homelessness was growing. The Coalition for the Homeless brought their lawsuit in the early 80s, trying to get the right to shelter established. So it didn't take a rocket scientist to figure it out. You destroy SRO housing, and the shelter population is increasing. So the city changed its mind and started taking away some of those incentives to convert the buildings. In fact, during the Koch administration in '85, there was a one-year moratorium on the demolition and conversion of SROs, and that led to the Blackburn study. It was a report that was commissioned to figure out how many do we have left. And at that point, the estimate was about 65,000 units in 1986. So over that 15-year period, from 71 to 86, 100,000 units, almost two-thirds of the stock was lost. Of those 65,000 units, the 70% were in Manhattan, so the bulk of these units are in Manhattan. They also found that about 40% of them were in the form of rooming houses, which were 29 units or less. So the majority of SRO buildings left tend to be rooming houses, but the most units are in the big hotels. There's not that many left, but the ones that are remaining can be 200, 300, 400 units, while the rooming houses could be anywhere be a 6-unit, 12-unit, 15-unit building. So they're smaller, but there's a lot of them out there. What do I say about that? Okay, then the size of the units. The size of an SRO unit, the minimum size has got to be 80 square feet for a single and 130 square feet for two people. That's very small, and that's people's homes in a lot of cases. You compare that to the micro units. If you recall, the Bloomberg administration was touting these new mini micro apartments. They were going to be anywhere between 250 and 350 square feet. Those would be palatial in an SRO. So you got to really understand, we're talking about small units. On a square foot basis, SROs are very profitable. They don't cost nearly as much to run as an apartment, and they're a lot more lucrative. They make a lot more on a square foot basis than you would with an apartment, because you're renting out every single unit possible. So I want you to refer to the Community Board 7 study. This is kind of just a snapshot of SRO housing in Community Board 7 on the Upper West Side. Community Board 7 runs from 59th to 110th Street. So this is kind of a snapshot of one neighborhood, but out of the remaining SROs, the bulk of them are in Community Boards 4, which is West Midtown, and Community Board 7 on the Upper West Side. So this study, this was done in response to conversions and losing SRO housing, and then what was seen as a growing problem in the early 2000, 2001, et cetera, was the growing use of the hotels for illegal tourism. So just flipping through that real quickly, what is an SRO, how many units, that's kind of defined there. Flipping up to where it says breakdown of SRO units, they found in Community Board 7, 13,364 B units were left. They were hotels, student housing. Many SROs are net leased or rented out by colleges for students because they need affordable housing if they want to further their education here. Servant quarters, there are some SRO units in big apartment buildings. We don't consider them SROs, but if you had a half dozen maids' quarters on the top floor, those are SRO units. There's nonprofit-supported housing, and then there's traditional SROs. The next chart there is a pie chart of the type of B units on the Upper West Side. And you'll see D, legal hotel use, is 3287, and almost twice that number, over 6,035, had tourists or city placements. They're being rented by the city for homeless families, or HASA rents them for people who have AIDS. So there's the city turns to SROs to shelter people at great expense. But that, of course, displaces rent-stabilized tenants. So that chart gives you a little breakdown. The next page there, this was kind of their cataloging of lost SROs. The SROs can be converted if a landlord does empty their building. They still do co-op conversions or convert back to 1 or 2 family houses. There's a process to do that. You'll see this certificate of non-harassment listed, Local Law 19. In the case of SROs, if a landlord wants to get an alteration permit and change the certificate of occupancy, they have to get a certificate of non-harassment before they get any permits. And what that entails is HBD will send out a notice to the community board, to the law projects, and ask if there's any history of harassment in a 3-year window prior to the application for the permits. And if there is a case of harassment and emptying the building or partially emptying the building, a landlord cannot get an alteration permit, and that will stop them from converting a building. Unfortunately, most of the time when there's an empty building, you don't have any history. It's very hard to put together any history, and getting a certificate of non-harassment is almost a rubber stamp, largely. It's a little time-consuming, but it's largely granted. There's only a few cases that our office is aware of where it was not granted. But then a loaner can wait the 3-year period and apply again, so that's what happens. But anyway, this demonstrates the numbers of buildings that were converted. The next chart there is a breakdown of they call market-driven B units, but these are units that are not being used as rent-stabilized units. They put alleged illegal hotel use and city placement only, and then market-driven, which is not a hotel or city placement, so I guess that means a deregulated apartment or market rate. The next chart there, this is a little dated because it's from 2006, but it shows what we had estimated to be illegal hotels who are renting out to tourists on a short-term basis. Now, you got to make a distinction that you can do transient rentals in SROs, but they're supposed to be 30 days or more. The way somebody becomes a rent-stabilized tenant in an SRO is by virtue of living there over 6 months or by doing what's called a lease request after they move in. They're statutory tenants. They don't have leases, unlike apartment tenants. So if you move into an SRO, you're supposed to be given a notice of your rights that the building is subject to stabilization, and you can trigger your rights as a rent-stabilized tenant thereby just by requesting a lease. You don't get a lease, and it's not a request, so it's a little confusing, but it triggers your rights to stay as a statutory tenant. Owners do not give out that rider, so people don't know, and tourists don't know they're living in a stabilized room. And owners have gone through extreme measures to make sure that they're not renting to a New Yorker who might do a lease request. They want to see passports, they want to see credit cards from out of state. They do not want somebody renting a room as a tourist and then turning around and doing a lease request and becoming a stabilized tenant. Some of these hotels, though, they weren't allowed to do transient rentals at all because they're not zoned appropriately. If you're on Broadway, you're in a commercial zone. You're over on West End Avenue in Riverside, it's a residential community. You're not supposed to do tourist transient rentals, but they were doing it in large numbers, despite what the law allowed. The next page there is about city placements. This is both the Department of Homeless Services for singles. It used to be families, homeless families would be placed in many hotels. They really stopped that practice to some extent. It tend to be more singles, and HASA are putting in those city placements. But back, going back to the Dinkins administration, you might recall the name, the welfare hotels in Midtown. You had the Martinique, the Prince George, the Times Square. A lot of these buildings are now run as supported SROs by nonprofits, but they used to be full of singles, rent-regulated tenants, and then they got displaced by homeless families, which the landlords made a fortune on. Then those homeless families were moved out, and unfortunately, nonprofits acquired many of those big hotels in Midtown. And the last page here is just some of the SROs that are now managed by nonprofits. And Goddard Riverside is one. We manage about 600 units of supported SROs at this point in time. So that's kind of the big picture. And I want to refer you to the charts that you have before you, the different memos in a chart. Now, historically, I've mentioned as provisos. Starting 25 years ago, the RGB approved provisos for SROs. The first ones had to do with the issue of warehousing. And we were able to document that many owners were emptying out their SROs in order to convert the building. And we said, if the landlord really requires a rent increase, why don't they maximize their rent roll first? Rent up the empty units, and then you could qualify for rent increase. They can't be crying poverty if half the building is empty. So the Rent Guidelines Board passed provisos that said if a building had X% warehoused or empty, therefore they would not get a rent adjustment. So that goes back historically over 25 years. In subsequent years, we were able to document owners making a lot of money by not renting out to stabilized tenants, but renting out to city placements or renting out to tourists. It's very lucrative. You can't compete. I know Magna, who's not here today, always loves to say, if you don't give SRO owners a rent increase, what incentive is there to continue to rent as a rent-stabilized apartment? There's no rent increase you could grant that's going to compete with the rents they can get from tourism or from city placements. You could give them a 100% rent increase. It's still going to be more lucrative to rent to city placements or to tourists. So there is no rent increase that you can give as an incentive, unfortunately, that owners are going to keep these as rent-stabilized units. We do our best to preserve them, but unfortunately, they can make a lot of money through alternate means of renting them out, and they're businessmen and women, and that's what they're going to do. The only thing that's preserved these buildings is having a nonprofit acquiring them and run them as supported housing. But still a very vital resource for those remaining tenants. So some provisos have been passed in subsequent years. If over an X% of the building is being rented out at great income for that owner, we've demonstrated that making a great rate of return in that building, and therefore a rent guideline increase is not warranted. That owner is making enough money. And then you compound that with how poor our tenant community is who live in SROs. It was a no-brainer for this board to grant zero guidelines a number of times over the last 20 years, as well as if there was a modest guideline with a proviso so that in buildings where it was clear a landlord was making a lot of money, you didn't have to grant an increase. So it's an instance where you didn't have to do a one-size-fits-all. You could differentiate a little bit based on the economics in a particular building. And that's something you could think about for apartments as well, but we won't go there today. So the memos, the first one was produced in 2007. It was based on data from DHCR in a prior year. How many SRO units are left is a good question. We estimate somewhere around 35 to 40,000. The data we have comes from DHCR, and it's what landlords do, reports it to DHCR. So pulling out from the memos, if you look at the legal size piece of paper, I made a little chart. On the left side is the last data we had from the Housing and Vacancy Survey. There's not enough SRO units out there for subsequent studies. Am I right, Andrew?
Yeah, my understanding with the HVS is they dropped that because it's all based on interviewing people, what kind of unit they are, and there was just not enough statistical data to keep doing that number, so they dropped counting that.
So we don't have data from the Housing and Vacancy Survey, but I did print it out so you had the last available data. And then the additional columns, which I've written in here, are numbers I pulled from these memos, because it's the only data we really do have available to us. You can see in 96, the estimate was 38,000. In 2002, it was 35,000. We still think it's around in that ballpark, 35,000 or so. But in terms of what's registered at DHCR, in 2005, there was over 15,000 units registered in 445 buildings. In 2008, it jumped. We found 7,000 units appeared, and about 30 more buildings reported that year. In 2011, this was actually data that was adjusted. It's 15,000 in 536 buildings. Andrew apparently had discovered last year in a 2012 memo that some large apartment buildings were incorrectly registering as rooming houses. I have no idea what the incentive would be.
We weren't either, but we eliminated them. Yeah, it made no sense.
Yeah,
So-
I mean, to qualify for the zero guideline, I don't think so. So I have no idea why they registered as rooming houses, but so the 2011 data was adjusted down to take out those big apartment buildings that shouldn't have been lumped in there. And then the 2012 data is 16,000 units. So we know there's an underreporting, but this is what's actually reported to DHCR. Also pulling out of that data in the 2011 and 2012 memos, they counted how many units were vacant. So you see in the 2012 data was 1958, which is about 12% of the reported stock was vacant or warehoused. The next line there that says exempt, one of the things that tried to do with the memos was determine what percent of the units that are registered with DHCR are being listed as exempt from stabilization or not containing a rent-regulated tenant. And the numbers have gone up a little bit each year from, over 25% of the building to almost 35% of the building is not being used for rent-regulated use. Now, that's the average. Typically, if you look at the data, if a building has one exempt unit, it usually has a large number of exempt units. There are, I'm sure it's the rooming houses and some of the smaller buildings might only have a few exempt units. But largely, if you have one exempt unit, you have a lot. And in fact, some buildings were registered as totally exempt, 100% exempt. So I don't know if that's accurate, if there are regulated tenants in those buildings, or they truly have, rid themselves of every single rent-regulated tenant.
Well, why, Larry, would they register then if all of them are exempt?
I don't know.
Well, is it because that if it's an exemption for a program, like you were mentioning the different programs, or the homelessness or whatever,
Right.
if that program comes out, don't those units technically go back as stabilized? Is that why they continue renting?
That's
Or
a good reason.
registering.
They should remain as rent stabilized even if.
Right, so if
technically
they pulled out of that program, those units would not, that's why they're temporarily exempt instead of permanently exempt? If there's a difference there, does that make sense?
Yeah, it does.
Oh.
It could be a temporary exempt, or they may claim, hasn't been used by a rent stabilized tenant for so many years, they would claim it's no longer subject to rent stabilization. They do try to do renovations and get the rent over $2,000, just like in apartments. It's just hard to believe somebody would pay that for an SRO. But the other thing that's kind of astounding is the mean and median rents on the bottom here that get pulled out from these studies. They're higher than apartments in some instances, especially if you look at the boroughs. But this is what's being reported by owners as the mean and median rents. I don't know if a tenant knows if they're paying. You actually have to look at the 2011, 2012 memos actually has the legal rent, the actual rent, and then the received rent. So what I've listed here is what the landlords are claiming as the legal rent. The actual rent and the actual rent received tends to be a little lower in terms of the mean and median, but still very high. And I also was astounded to see that in some cases, Brooklyn and the outer boroughs, the mean and median rents were higher than Manhattan, which wouldn't make sense, but I think it's a reflection of the rent stabilized tenants in the big hotels in Manhattan who know their rights, have been coming to the law projects for years, their rents are registered with DHCR. I think rooming house tenants in the outer boroughs might not know their rent stabilized. Landlords are probably getting closer to market rents, and they're just not registering the unit so the tenant doesn't know that the unit is subject to stabilization. But that's the only reason I could explain why the median rents outside of Manhattan would be higher. And obviously, it's very different for apartments.
Are you eligible for SCREE?
Yes.
You are, but not Section 8? Because you wouldn't have your
Well, if an owner was willing to accept a Section 8 certificate, yes. There's no reason why you couldn't rent an SRO unit. And yes, there are many seniors,
SCREE.
AC among them, in the back here, who relies on SCREE. But we don't think you should be even given a rent increase, so we don't want to go to SCREE route because we think there's a good argument for no increase. So anyway, these memos, just the last thing on the memos, the first two memos, if you look through them, they went around the city and looked at different areas of the city, different communities, the number of buildings and the number of units. I think the idea was they wanted to determine how many buildings would not qualify for a rent increase based on these provisos. And the provisos changed, from the first memo in 2007 to the second memo in 2009, they went from 20% to 15% exempt. So if you had 15% or more deregulated, you were not entitled to rent increase. So that change of 5% meant a majority of buildings would not qualify for the Rent Guideline Board adjustment. And that remains the case with the exemption being at 10% or 15%. The bulk of the buildings, the majority of SROs would not qualify for Rent Guideline Board increase. There was a little debate about whether provisos were actually lawful for a while. Apartment tenants had tried to get some provisos a number of years ago. The chair at the time got a corp counsel to do a memo saying provisos weren't permitted, weren't lawful, and legal aid created a memo saying they were. And then landlords got a poor tax approved in subsequent year. They called it the supplemental rent increase for apartments that rented under $1,000. But basically, it was a proviso that granted a higher increase for apartments. The rationale was these are low rent apartments. These are buildings that are presumably making less of a rate of return, and therefore they deserved a little higher increase. Legal aid sued and said that wasn't permissible. The courts ruled that it was. So you are allowed to do provisos. So that just as an aside for you, but that had been argued back and forth. They are lawful, and it is something that can possibly be considered for apartments, but they are legal for SROs. So in summary, and they'll substantiate with some more data and information, we think that so many of the SROs would not qualify for the increases because of the provisos, and the provisos are also difficult to enforce for a number of different reasons. We think a zero guideline increase is again warranted. So I've probably gone over my time. I'm going to shut up. Fast ahead.
My name is Brian Sullivan. I'm from MFY Legal Services, SRO Law Project. I think I've been testifying for, I think this is my third year, and I always go directly after Larry. And every year I say, okay, next year's going to be the one. I'm going to somehow edge ahead of him so he doesn't say everything we're saying. But this isn't that year. But I still think I can fill in a few extra details. MFY's been working in SROs for a long time as well. We cover the outer boroughs and the east side of Manhattan. And I don't know how many of the board members are familiar with SROs. I want to give some basic description of the physical arrangement of SROs and some of the unique legal characteristics of SROs. Larry had mentioned the extremely small square footage, and it's a telling sort of figure. These are very small units, and they exist in all sorts of buildings, as Larry also pointed out. There are a number of large buildings that somewhat closely resemble traditional hotels. One building we do a lot of work in is called the Greenpoint Hotel in Brooklyn, in Greenpoint. It's a close to 200-unit building, stairs, long hallways, communal bathrooms, and I guess that's the main difference from a modern hotel that you might have stayed in. But those look more or less like hotels. Some are in smaller buildings, and they're sort of like studios, except normally without their own bathroom and frequently without any cooking facilities. Some, sort of the most dramatic example are the Bowery SROs, where there'll be a large loft space that's been divided into cubicles. So it'll be large loft space with plywood walls and chicken wire ceilings. There'll be, maybe 100 or more units on a floor, and these are very small units. And some of them you could reach out your hands on either side and touch both walls. And so what Larry was mentioning about rents in SROs, if you're paying, say, $300 a month for a room that small, the $300 may seem like a small figure, and on the one hand it is, but you are paying a lot per square foot. And it's part of the reason SROs even exist at all, is you get very high land rents when you had things that closely packed in. There's such a huge range of SROs. I mean, Larry pointed out in one of the charts, there's the rooming houses, boarding houses, hotels, just this sort of heterogeneous mix of things. And the laws do a decent job of covering that up. But just to highlight a few aspects of the legal scenario with SROs, because they're unique, and because of the sort of catastrophic collapse of the SRO market over the time period Larry was talking about. I think he mentioned a drop of 100,000 SRO units. Just to put that in some perspective, the New York City Housing Authority has 175,000 units citywide. Imagine if 2/3 of NYCHA units ceased to exist over the course of a couple decades. What a catastrophe that would be. And that's what happened with the SRO market. It shrunk very quickly, very massively, and it was a huge, huge source of affordable housing. The city and state reacted to this by providing unique legal protections for SROs. So as Larry pointed out, you become a tenant simply by being there for 6 months or making this lease request. And the Rent Guidelines Board has appropriately awarded smaller rent increases because of, in part because of how crucial this is as low-income housing. There's some other factors there as well that Clint will talk about in a little more detail. SRO owners are able to find other profitable operating strategies. And again, Clint will give you more information there. I think the one or two more points I want to make is there was a little discussion about the exemption. We noticed that the exemption in SRO is being abused frequently by building owners. An exemption can be put in place when you have a temporary tenant. So if you have, the Greenpoint Hotel, returning to that example, they're Class B units, and you could have transient residents there. At one point in time, a previous owner of the hotel, not the current owner, just filed every single room in the hotel as temporary exempt, said everyone is living here transiently. That was simply not true. There were residents who had been there for 10 years at that point, but they did this so that they could then illegally start increasing rents year after year. You can charge whatever you like to a transient tenant. And so at the same time that they did that, they registered much higher rents year after year because they said, these aren't rent stabilized tenants, these are transient tenants. We can charge whatever we like. That's, I think, one of the reasons that we've seen that owners will do that. The other issue that will arise there is if you have a temporarily exempt unit, you don't necessarily have to register any rent. And if you can maintain that sort of facade for a period of 4 years, you can cynically take advantage of the 4-year look-back rule and make subsequent overcharges very difficult. So SROs have this unique legal framework that allows for some unique abuses in that way. I guess the final thing before I hand it over to Clint is reinforcing another point that Larry had made, that there's no increase that makes renting to stabilized tenants more appealing to SROs. They find enough alternative profitable strategies, and the rents are appropriately very low. This is the housing of last resort for many, many New Yorkers. I think someone who testified previously had talked about people living in the city in sort of an integrated way. People who work here get to live here. This is very much a factor with SROs. You have a lot of senior residents, you have a lot of people with disabilities. For them to be able to live in the city near the services they need, for them to be able to live near their hospitals, near food, just in the neighborhoods they've lived in for a long time. SROs are crucial for that. Even though there's relatively few, they still provide a very important resource in that respect. So for all those reasons, we would ask that, again, the board approve a 0% increase this year.
Thank you, Brian. Thank you, Chairwoman and members of the board, for permitting me to testify here this afternoon. My name is Clint Guthrie. I'm the Assistant Director and one of the attorneys at the Goddard Riverside Community Center SRO Law Project. And it's a great honor to be here to talk about issues affecting SRO tenants and tenants in residential hotels. So just a brief word about the SRO Law Project. Like the work that both Brian and Larry do, our work is organized around supporting and preserving SRO housing. We do that through tenant organizers as well as attorneys, doing eviction prevention, outreach, and organizing with tenants and direct advocacy with city agencies. So in addition to the litigation in defending tenants, we bring affirmative HP cases to improve conditions in SRO buildings. And some of our work has even brought benefits citywide to SRO tenants. Both Brian and Larry mentioned the ways in which an SRO tenant gains permanent tenancy status, and our recent appellate case, Brannick International Realty versus Pitt, an appellate case reaffirmed that SRO tenants can gain tenancy rights from 6 months of continuous occupancy, which the law is specific for SRO tenants because it recognizes their vulnerability, and it creates this special way in which they can gain tenancy. Otherwise, it may be difficult for tenants who are vulnerable in this position to gain permanent tenancy rights, which come with all of the protections of rent stabilization. So in acknowledging the lack of resources and lack of housing alternatives for this vulnerable community, the board has voted for 0% increases the last 2 years, and we applaud the board for doing so, and reiterate that those votes properly took into account the need to maintain rents at a very affordable rate for this community, and without compromising the ability of owners to profit from their investments, which, as I will point out, they are doing so in various ways. So as I appear before you in 2014, the conditions that warranted increases or warranted 0% votes in 2012 and in 2013 remain essentially unchanged. SRO tenants of limited means continue to struggle, while the buildings, many times these SRO buildings, are increasingly used for other more profitable uses by the building owners, which Larry touched on in his testimony. So just briefly about the financial economic situation for SRO tenants. Just from the RGB's own 2014 income and affordability study, the rent-to-income ratio for all tenants is 33.6% and is even higher for rent-stabilized tenants. Even more disconcerting, 34.8% of rent-stabilized tenants pay 50% or more of their household income on gross rent. And we certainly observe this reality with our clients who live in SRO buildings, who frequently pay a substantial portion of their income, whether from governmental benefits like SSI or HRA shelter allowance, or from employment income on their rent. One example, we have a client, 70 years old, who lives in an SRO building on West 86th Street, only is able to pay her rent, and she diligently pays her rent every month through a combination of HRA shelter allowance and from a small stipend that she gets from an organization that assists survivors of domestic violence. after her rent is paid only through food stamps and a small amount of public assistance of less than $200, does she pay all of her remaining expenses. And she is barely able to do that. And for tenants like her, any further increase, even a small amount, would have potentially catastrophic circumstances for someone like that, vis-a-vis the kind of profits that the SRO owners are currently making. Many of our clients routinely report incomes of $10,000 or less a year, and the city's homelessness problem, nightly average in 2013 of 49,408 persons, would be exacerbated by more SRO tenants losing their housing if rents were increased anymore this year. The low vacancy rates overall in New York City demonstrate building owners are able to rent their units to permanent tenants. Many SRO landlords, however, are making other profitable uses of their properties that are not renting to permanent rent-stabilized SRO tenants. As Larry talked about, the Community Board 7, 1,336 SRO tenants were lost units were lost in that board between 96 and 2010 alone. Just to talk briefly about the city contracts for some of these buildings, in one pair of buildings that have been in the press, the so-called Freedom House, 2 SRO buildings, 316 and 330 West 95th Street, where the average legal regulated rent for those buildings is $300, approximately $300 a month. The landlord, however, made this arrangement to operate a homeless shelter to provide 200 rooms to 400 homeless families at a monthly cost of almost $3,700 per room. While we're heartened that Controller Stringer and Borough President Gail Brewer have negotiated an agreement with the Deputy Mayor and DSS to reduce the shelter population to 200, all of the rooms that are being used in these buildings could be made available to the homeless clients staying in those buildings at affordable rent-stabilized rates, and they could be permanent tenants. Instead, the building owners are profiting, and the rents that they're getting from the permanent tenants don't even go to the operating expenses. Instead, these buildings have become quite profitable through this arrangement. Other SRO tenants, as Larry touched on, are also renting out to on a transient basis to tourists on a nightly or weekly basis. Although the law was strengthened in 2010 to sort of clarify that such use of the buildings was illegal, and increased enforcement has helped curb this practice, we are still aware of many SROs continuing to skirt the law and charge exorbitant rates for these buildings that are actually SRO buildings for permanent tenants. To take one example, the Alexander, an SRO building on West 94th Street, which bills itself on its website as an extended stay hotel specializing in stays of 30 days or more, nonetheless lists daily rates, which range from $58 to $77 per night. So what that comes out to on a monthly basis is $1,740 to $2,310 a month, which is well in excess of the appropriate legal rents for SRO units like this, which should be considerably lower. But the building is making great profits from these kind of uses of the buildings. Also, they use Airbnb, which has been in the news a great deal recently, to rent rooms to unsuspecting tourists, which may be rent stabilized. And this illegal renting has led to the Attorney General to recently issue subpoenas to determine the list of hosts that are involved, who we believe would include some SRO landlords who are making this illegal use of their buildings. Some SRO owners, in addition, will just warehouse their units. They will keep them vacant, most perniciously to more easily obtain certificates of no harassment, which Larry discussed, which they would need to convert the building to another use. If the building is mostly empty, it's much easier to prove that there hasn't been harassment in the last 3 years, which is what they need to do to obtain a certificate of no harassment. In the SRO Law Project's catchment area, which is on the west side from 14th Street to the top of Manhattan, we're aware of several traditional SRO buildings that have large vacancy rates. To name only three, the Imperial Court at 307 West 79th Street has approximately 63 permanent tenants in a building with 227 SRO units. The Alexander, which I mentioned before, 306 West 94th Street, has 6 permanent tenants by our count in a building with 114 SRO units. And perhaps most egregiously, the Camden Hotel at 206 West 95th Street has 1 permanent tenant left in a building with 207 SRO units. They're currently trying to obtain their certificate of no harassment to change the classification of that building, which obviously becomes much easier to do when there's only 1 permanent tenant remaining. So SRO owners making uses of their building, whether through warehousing, whether through the transient hotel use, or the lucrative city contracts, certainly don't deserve any guideline increases. Conversely, the tenants in their buildings who are frequently harassed and must struggle on limited incomes to diligently pay their rents, any increase for them would certainly bring a catastrophic consequence and would reward these landlords for their unscrupulous and illegal actions. And just finally, a word about the provisos, which both Brian and Larry discussed. Although you may consider a proviso such as those that were passed before 2012, it is our position that the SRO owners don't deserve such an increase. What I will talk about briefly is just the difficulty in tenants challenging these proviso increases when landlords take them. Our office represents several tenants in a building, SRO building at 1234 Broadway, where the landlord back in 2012 took illegal increases, claiming that the building was at least 85% occupied by permanent tenants. So those tenants had to, at 3 levels, challenge those overcharges. They had to bring complaints with DHCR. Then the landlord appealed, a petition for administrative review. With assistance from our office, those decisions were upheld. The landlord then appealed to Supreme Court, and finally, Supreme Court cases involving all of these units upheld the overcharges. So we were very happy with that, but the total process took, well over a year and really close to 2 years for them to be able to simply challenge this illegal proviso increase. So the risk of similarly illegal increases is high, and many tenants fearing retaliation simply pay the increases without challenging them. So as a result, we would request that you merely vote for the 0% increase without any proviso. And thank you again for your giving me this opportunity to testify today.
Anyone questions?
A quick one. The Times Square and the St. George, when they converted, I assume they leave the program, that they have other sources of income, or are they still under the Rent Guidelines Board recommendations?
Times Square is now known as a Common Ground.
Yeah.
It was one of the biggest. It was about a 700-unit
Yeah.
building when
And
Common
St.
Ground
George is
acquired it.
huge, too.
Yeah.
They're both Common Ground, I think, aren't they?
I believe so, and a Prince
Yeah.
George as well. But yeah, I worked with the tenants before Common Ground took it over. There was probably about 250 rent-stabilized tenants out of the 700 units when Common Ground acquired it. And it's mixed use. I mean, they don't have any one population, but many different populations. And it's run very well.
There, a lot of the Times Square and Prince George units are still affected. A number of the tenants get a preferential rent, so the rent will be, $1,800, something like that. They'll get the preferential rent of $500. However, they are still affected by by what this body does for, I believe, all the tenancies. I could be wrong about that. I think when they renovated, they took advantage of the private housing finance law, and part of that deal. Don't quote me on this. I'm not 100% positive this is right, but I believe as part of that deal, all the units became regulated, so they would be affected.
But the rents are also restructured in those buildings, too.
Just quickly, if you can. I mean, I think you identified or defined SRO buildings and rooming houses. I believe, Brian, you were speaking to a lodging house situation with the chicken wire And that generally is called a lodging house for the most part.
Sometimes sort of more disparagingly, a flop house.
A flop house, but that's sort of,
but
and
yes.
then, just for the edification of the board, the residential Class A and Class B hotels, if you could just quickly define that, and do you find that there are any or very few stabilized units left in those?
Well, there's still many left. I mean, our friend AC back here is in a Class A residential hotel, formerly the Commander, now it's called Tempo. And how many units are still occupied by rent-regulated tenants?
We had 222 units when I moved in 1981. We now have 200 units. They disbanded them illegally, and we have 68 rent-stabilized units left.
So it,
The other 131, 232 units, they are paying $1,000 a month, $2,900 a month, etc.
and that building, they're all self-contained. So they're studios or one-bedrooms, but they had hotel services. There used to be a switchboard, the linen service, maid service. Those services are all gone, but it's still a Class A residential hotel.
Okay.
There's a few others out there as well.
Okay. And then the Class B?
In our catchment, we have quite a lot of them, actually.
Okay.
I'd say, we get a good chunk of smaller lodging house, rooming house type operations, but a fair amount of Class B units. The Greenpoint Hotel, which I mentioned, is a Class B
Class.
residential hotel. There's some that are sort of this strange mix. The Jolly Madison Hotel, which is sort of a boutique hotel now with some very high rates, nightly rates, and then one floor of Class B tenants. So you get some unusual mixes like that. But it's still a pretty significant number of Class B units.
I also just wanted to mention real quickly about the tourism. It was always an issue in SROs. We called it the transiency loophole. Going back to the 80s, we were trying to close that so that when you moved in, you were just a rent-regulated tenant and not a transient. But as tourism grew and the city got more and more popular as a tourist attraction, some of the hotels did cater more and more to tourists. But when the internet really burst on the scene and outfits like Airbnb could really advertise and facilitate it, that's when we went off the hook. And it spread to apartment buildings, that's really caught the public's attention, that anywhere between 40 and 60,000 units could be listed a night available for short-term rentals. And these are largely apartments and SROs that should not be available for those short-term rentals. But it's a huge issue. Airbnb is spending several $1 million lobbying Albany. I heard there's an ad running in Grand Central about Airbnb lately. But they're going to do an initial public offering, and I think it's estimated between $8 and $10 billion, this company and this model. And if they can do it in New York, they can do it anywhere. So that's why they're fighting tooth and nail to weaken the laws that we had gotten strengthened a number of years ago.
Thank you so much for coming this afternoon. Do I have a motion to adjourn?
And we will send Andrew a request to meet with some of the new members to, if you would like, be happy to sit down with you to talk more about
That would
SROs.
be great. That would be great.
Thank you.
Very quickly.
So today we heard about, 1 and 2 year lease renewal adjustments that the apartment folks are dealing with. The SRO increases hotels to 5 classes. The other role and job of the board is to set a special guideline for those units going from rent control to rent stabilization. So when a rent-controlled apartment becomes vacant, they're going to rent stabilization. So there's going to be a discussion about that at the preliminary vote. So I just want to put you on the radar so you don't feel like, oh, what else are we doing? What is this about? So if you have questions about exactly what that is, certainly let me know. But those are the 3 components the board has to set on Monday. So.
Is there any way we could, sort of like a breakdown of what you just sort of told us?
It's in the intro.
Okay.
So there's a section on the special guideline and what that means.
To the extent anyone hasn't read this is the greatest resource ever. It really does clarify what our role is in a really helpful way, and it's really clearly written. And it looks more daunting than it is. There's lots of exhibits and tabs that one doesn't necessarily have to read carefully, but just the description that he provides of the history of the board and the different roles and responsibilities, I would urge you to take a look at it. May I have another?
I move to adjourn.
Second.